stand by while NCLA cuts through the noise to signal abuse of administrative power. This is Administrative Static with Mark Chenoweth and John Vecchione.
Welcome back to Administrative Static. Mark Chenoweth here, and John Vecchione is in his own private Idaho today. So we are joined by, or I am joined by my another one of my senior litigation colleagues here at NCLA, Russ Ryan. Welcome back to Administrative Static.
Thanks for having me again, Mark. Glad to be here.
Well, so the reason that we asked you to pop on the program today is because you have secured another Amicus victory for the New Civil Liberties Alliance at the U.S. Supreme Court. The case is Harry C. Calcutt III v. Federal Deposit Insurance Corporation. It was decided on May 22nd. It's a per curiam decision, meaning that no justice's name appears on it. And this happens sometimes when I guess the court thinks it isn't a close question or there isn't anything particularly new and interesting that it's saying. It's just sort of reaffirming law that's already on the books. But maybe you can tell us, Russ, what happened in this case.
Sure. And I think it was a per curiam, probably because Calcutt had raised two issues presented, but the government essentially conceded the first one. And we can talk about that later. So it didn't surprise me that the court disposed of it with a relatively short per curiam opinion.
Path of least resistance sort of idea. Yeah. Okay. And we weighed in on the second issue, which the court didn't reach in this case.
Yeah, that's right.
Okay.
That's true.
But we count it as a victory anyway.
Yeah, of course.
So what did the FDIC do here? What did Mr. Calcutt do? What was the controversy?
Okay. Well, this was sort of a typical administrative process at the FDIC where they accuse a banking official of engaging in unsafe, unsound practices and so forth.
Mr. Calcutt was the CEO of a Michigan-based community bank.
Yes, Northwestern Bank, I think it was called, in Michigan.
Okay.
So one of the amazing things about this, the conduct dates back to 2008, I think, 2009. The investigation didn't start until 2013. Here we are in 2023.
I think it ended in 2013. I think they started the investigation in 2012 and ended it in 2013.
I think you're right. But in any event, here we are 10 years later. Mr. Calcutt finally, quote unquote, wins at the Supreme Court after all these years of litigation. And what's his remedy? Go back and start from square one again before the FDIC. And, this goes larger than this particular case, but it's something we see on a daily basis in NCLA. And it's really frustrating.
I think Justice Gorsuch might say this is what a win looks like
exactly.
in the administrative process.
That's exactly. In his opinion in the Axon case. Yeah, that was nice.
Yeah. No, it is troubling that it takes almost 10 years to get to this point, and to this point is starting over at the bottom of the hill, pushing that rock back up again. Well, what was the issue? What was the first issue that the government conceded error on? What was the sort of the non-controversial point here?
Yeah, so it goes to proximate cause. The FDIC had ruled in the administrative proceeding that it did not have to establish proximate cause between Calcutt's conduct and whatever losses were suffered by depositors. And then it went on to hold that, well, he was a cause. The Sixth Circuit actually disagreed on both points and said, no, it's pretty clear from the statute that you do have to establish proximate cause. And in this case, much of the loss cannot be said to be proximately caused by Calcutt himself. But notwithstanding finding those two significant errors, the Sixth Circuit basically scoured the record on its own, sort of de novo, and came up with the conclusion that, well, those errors probably didn't affect the ultimate sanction, and so we're going to affirm the sanction anyway.
Trying to put the case out of its misery, perhaps.
Yeah, and I think in part because it was so old. If you read between the lines, it seems like the judges are saying, are we really going to send it back again for more years of litigation when the result is likely to be about the same thing?
Right, foreordained in some sense.
So the Supreme Court, and I think the parties both agreed that under a longstanding case called SEC against Chenery, the role of
that's not Chenoweth. That's Chenery.
Right.
It's administrative law geeks know this case.
It would have been U.S. against Chenoweth.
Oh, thanks, Russ.
So under the Chenery doctrine and its progeny, where a reviewing court finds errors, it's to confine itself to the record that's before it and the reasons given by the agency. And if it disagrees, it should remand it back to the agency for reconsideration. Now, that interestingly, I think we're also seeing, apart from this case, some academics at least questioning whether remand is a permissible remedy, but that's a different issue because the review statutes usually allow the reviewing court literally to affirm, modify, set aside, and they
not remand for a second bite at the apple.
Yeah, and a lot of these statutes, there's not explicitly a remand option for the court, and I think actually George Jarkessi is raising that in his cross petition for cert in this Jarkessi case. I don't want to go too far down that rabbit hole, but it's an interesting side issue.
It is an interesting side issue, and Chenery is a building block of modern administrative jurisprudence, I guess you could say. So if that does get called into question, that'll be an interesting development. Well, so what else would you like to say about this case, Russ? You want to talk about the issue that the court didn't reach, or?
Yeah, we could briefly talk about that. What the court did, there was a second issue, and it was that the ALJ who decided the case against Calcutt was unconstitutionally protected by multiple layers of removal protection from the president. That's an issue that's also involved in Jarkessi. The Sixth Circuit mentioned the issue and said, well, we're not sure he's right on that, but even if he is, we can't really give him any relief. And they cited the Collins against Yellen case and the Celia Law case, where the Supreme Court gave sort of Pyrrhic victories to those people, and even though they prevailed. So what the Sixth Circuit did in this case was it said, well, we're not going to decide whether this ALJ was unconstitutionally protected from removal, because even if we agreed with Calcutt on it, we can't really give him any relief because there's no proof that the outcome would have been any different, even if everybody knew that the ALJ was removable at will. And our brief basically said, no, that puts the cart before the horse, that if there's a constitutional violation out there, a court's duty bound to decide it, even if the remedy it could afford is largely Pyrrhic and disappointing to the challenger. And the reason is that separation of powers cases tend to be, the important ones tend to be brought by individual citizens like Calcutt. And we want to encourage those as much as possible. We don't want to discourage them. And if we send the signal to people like him that even if you're right on a constitutional challenge based on separation of powers, you're not going to get any remedy anyway, who's going to bother to raise those challenges? And that'd be a problem. But
Yeah, it absolutely would be a problem, and I think that well, as you say, this issue comes up again in the Jarkissi case. So if the court decides to hear that, it'll grapple with that issue there, presumably.
Yeah, I think he's got a little better situation because I think he raised it early on.
He raised it. He did. He raised it early on, and that may be a way of distinguishing his situation. That, hey, I tried to go to federal district court ahead of this, and solve the problem ex ante, and you didn't let me. You said there wasn't subject matter jurisdiction to hear the case. Well, the Supreme Court has now said that there is subject matter jurisdiction to hear the case. So don't come back and tell me now that because you wrongly decided the question of subject matter jurisdiction the first time that I don't get a remedy on the back end.
Yeah, no.
that would be some strange cooking if that's what the court decided.
Yeah, well, our brief was filed before Axon and Cochran were decided. So we pointed out that there's this no-win situation here, that if you raise it early in district court, you're going to get thrown out of court for lack of jurisdiction. You can't really raise it during the proceeding because these administrative proceedings have very little discovery, and you're probably not going to get any discovery to try to prove that the outcome would have been different if
right.
So, and then prior to Axon, most of the courts had been throwing these cases out early. And then if you have a case like Calcutt where you come after the fact and the court says now it's too late.
Yeah, it didn't make a difference. Yeah. They got you coming and going and in between.
Yeah. So.
Yeah. Well, so again, Calcutt v. Federal Deposit Insurance Corporation is the name of the Supreme Court case, and Mr. Calcutt will be going back down to an ALJ in front of the FDIC, I suppose, to start over. But thank you for being with us today, Russ, to explain what happened in this case.
Thank you.
Welcome back to Administrative Static. Mark Chenoweth here, and I am joined by my litigation counsel colleague at the New Civil Liberties Alliance, Sheng Li. Sheng, welcome back to Administrative Static.
Thank you, Mark. Happy to be back.
So Sheng is here because he has a victory to tell us about, and this is maybe a sort of unusual victory, Sheng. It was sort of, I don't want to say we backed into this one, but your good work here exposed some goings on at the agency that essentially led the agency to turn tail and run. So the case is Polyweave. Was this Polyweave v. Department of Transportation or Polyweave v. Buttigieg, or I guess both?
It was there were two, and one of them was versus Department of Transportation. But the main one is the versus Department of Transportation. And the reason there were two cases is before NCLA's victory in Cochran, in the Sixth Circuit, as most circuits, you had to bring challenges to administrative adjudications after everything is done, even if there were structural constitutional problems in the adjudications. But after NCLA's Cochran victory, we can now go proceed directly to court.
Perfect. So this all happened after the fact, and what happened when? So, in other words, the case got to the Sixth Circuit, and then what happened there?
Yeah. So what happened was the Department of Transportation imposed a civil penalty after a really like a Star Chambers-like in-house administrative proceeding against our client. We challenged that civil penalty in the Sixth Circuit, got it vacated and remanded back to the agency, which just last week decided to dismiss all counts rather than try to re-prosecute our client. And a bit of background on this is that there's these regulations that the Department of Transportation enforces called the Hazardous Material Regulations. And the statute says the department can impose a civil penalty only if a company knowingly violates those regulations. Now, the thing that
And
our
these are
client
important
Polyweave.
regulations. I mean, we grouse about regulations a lot, but hazardous materials regulations, I mean, you don't want people making mistakes when they're transporting hazardous materials around the country and what have you.
Sure, but they're also very complicated. And then the reason why Congress put the knowingly scienter is to make sure that innocent sort of mistakes, like the one our client allegedly committed, don't result in civil penalties. And here's what our client did. There's these our client makes packages that transport hazardous material, and some packages called combination packages need to be retested every 2 years, but a composite package needs to be retested only 1 year. And let me just read you the regulatory definition of these. A combination package is defined as a combination of packaging, which using it in the definition, not great, consisting of one or more inner packages secured in a non-bulk outer packaging. So remember that, inner package in an outer packaging. A composite packaging, in contrast, is a packaging consisting of an outer packaging and an inner receptacle, so that the inner receptacle and the outer packaging form an integrated packaging. Like, how are you supposed to know? Our client makes a 2-layer packaging. How are you supposed to know if it's the outer layer is an inner packaging secured by an outer packaging on one hand, or if the inner receptacle has an outer packaging?
Well,
and so
why one of those would have to be tested every year and why the other one would be tested every 2 years.
Exactly. That too. So our client, like a good company, actually called the agency back in the 1990s and said, hey, which one is it? And the agency told them it was the combination, which is 1-year testing. Fast forward about 20 years, the agency comes back and says, actually, it was 2-year testing. You failed to test your packaging, and here's a fine. And that was around 2015. And so the agency then dragged the clients through 6 years of just this ludicrous proceeding, during which it went through 3 presidential administrations, during which the Trump administration actually enacted new due process protection regulations during this time, to which the client was entitled to during the administrative proceedings. And then in the midst of those administrative proceedings, the Biden administration pulled the plug and took away those due process protections. So
that's
the client
right. Never mind. You don't need no stinking due process. Yeah, that was
exactly. And all of this, these sort of abuses just piled on and on and on until finally, when a final agency decision was issued back in fall of 2021, we filed suit to challenge
we got involved.
Yep, we filed suit to challenge the final agency decision and raise a number of arguments, including that the agency, just failed to even allege that any violation was knowing, especially given the fact that its own definitions are convoluted and indecipherable. And our client could not have committed a knowing violation because they asked the agency, and the agency told them to test it every 2 years rather than 1 year. Anyway, so
that's why we took this case in part, because we thought, well, gosh, this is pretty open and shut in terms of the client's innocence here.
In addition, we mounted a full-throated attack against the administrative proceedings themselves, arguing that firstly, that the guy who ultimately adjudicated who issued the final agency decision, it's the agency's chief safety officer, who's a career employee, not a political appointee. He's a career employee who's actually protected from removal and discipline from the president, and that violates the take care clause
by civil service protection.
Yeah, exactly. He can't be removed except through the Civil Service Protection Board, and the president can't actually remove any of those guys either. So he's doubly protected from removal, which the Supreme Court in Free Enterprise said was a big no-no.
And that's the distinction from. So, for example, if you have a prosecutor at the Department of Justice going after someone, that's underneath the auspices of the U.S. attorney, who is presidentially appointed, Senate confirmed, and can be removed whenever the president wants him to.
Exactly. So the idea is, because the president can discipline the guy's boss, the person who controls, who affects the guys, the officers, to supervise the person, that's enough under free enterprise. But here, the president can't even do that. Next, we also say, wait, look, you can't impose a civil penalty without a jury trial, and that goes all the way back to the founding of the republic. And just because a statute creates a civil penalty doesn't get you out of the requirement of jury trial. And here, there was no process in the agency administrative proceeding for jury trial. And finally, we brought some due process arguments that one, you can't just like pull due process regulations that our client enjoyed, 1 month and suddenly not enjoy in the next month. And so instead of confronting these arguments on the eve of its responsive brief, the Department of Transportation disclosed something even more shocking, and that's the head agency adjudicator who issued not only the final decision against our client, but the final decision against dozens of other companies over the last several years, was never properly appointed to adjudicate agency adjudications. And this goes back to a 2018 Supreme Court case called Lucia v. SEC. Ray Lucia is a former client and a new client of our firm, and that case said that because agency adjudicator exercise significant power, they have to be appointed by either the president or the head of a department, that is the secretary. And when Lucia came down, the Department of Justice went around to all the agencies and says, hey, you guys, if you guys have agency adjudicators, you need to get the secretary or maybe the president, but mostly the secretary, to go and appoint them or reappoint them.
Right. DOJ sent letters to every agency and said, correct your Lucia problem if you have one. And this was several years ago that this happened.
Exactly. And DOT just did not do that. I don't know if they missed the memo or what, but they did not do that. The head adjudicator was not properly appointed. And so they went and asked the Sixth Circuit, can we have a do-over? Can we don't want to respond to these hard arguments. So what we're going to say is we're going to just admit to this, rather outrageous constitutional violation. Again,
in a
different
clients are there.
Yeah, and in a separate case, the solicitor, I think it was not the Solicitor General herself, but one of her one of her attorneys to the Supreme Court said, look, trying to defend some other outrageous government conduct. This is actually the Axon decision that's companion to Cochran. Said, look, what the government doing surely isn't bad as a Lucia violation, because if you committed a Lucia violation, that would be grounds for mandamus relief. So that's exactly what happened
in the oral argument. They said this,
in the oral argument. But that's exactly what DOT did here. It not only has it committed a Lucia violation, but it did so for ever since 2018. It didn't correct it until July 2022 when it admitted this to court. And what's crazy is it admitted this to court on July 25, 2022. On July 27, 2022, 2 days later, the same improperly appointed chief safety officer issued another civil penalty order against a company called Metal Conversion, which NCLA just decided to represent a few months ago to challenge that. But that case is still pending. But that seems to be, a pretty open shut case where the agency not only admitted that it was committing this terrible violation for many, many years, but didn't seem to fix it, or wasn't very interested in fixing it, and had the same guy continue his duty.
So we have less than a minute left here, Sheng. What else does our audience need to know about the Polyweave matter? Where does it stand now? It's been completely dismissed? Yeah, it's completely dismissed now. Went back to the agency, so the agency took a look at it, and I think what really got the agency to drop everything is again the victory in Cochran, because now if the agency tries to re-prosecute the client, we would just come in and we'd actually threaten the agency with this. We would come in and just bring our host of full-throated attack against the agency directly in district court this time. We don't have to wait anymore for the agency to rule. But I think that reprieve will be short-lived, because stay tuned. NCLA is planning to bring further lawsuits against this crazy labyrinthine administrative proceeding of DOT agencies. That's right. He's not the only person or Polyweave is not the only company that the agency has done wrong by. So thank you, Sheng, for being with us to explain this case, and congratulations on your victory. Thank you.